Get ready for dictation. Start. Making the above submissions, it is prayed to allow the present appeal and direct the respondents to appropriate the payment of rupees 1.25 crore towards settlement dues under the scheme 2019 and that discharge certificate be issued to the appellant accordingly. While opposing the present appeal, learned ASG, appearing on behalf of the Union of India, has vehemently submitted that in the facts and circumstances of the case, no error has been committed by the Honorable High Court in dismissing the writ petition and refusing to direct the respondents to accept the payment towards the settlement dues under the scheme 2019. It is submitted that admittedly the scheme was valid up to 30/6/2020 and the last date for payment of settlement amount under the scheme 2019 was 30/6/2020, that thereafter the scheme was closed and even the designated committees were also dissolved, and therefore, as rightly observed by the Honorable High Court, the Honorable High Court has no jurisdiction to extend the scheme. It is submitted that if the scheme is extended, it would create many complications. It is further submitted that in the present case, admittedly, no payment was made of settlement amount under the scheme prior to 30/6/2020, and therefore the prayer of the original petitioner to extend the time limit to make the payment of settlement amount under the scheme 2019 was rightly rejected by the Commissioner, and the same has rightly not been interfered with by the Honorable High Court. Making above submissions, it is prayed to dismiss the present appeal. We have heard the learned counsel appearing for the respective parties at length at the outset. It is required to be noted, and it is not in dispute, that the appellant is entitled to the benefit of the settlement under the scheme 2019. The scheme 2019 came to be introduced on 1/9/2019, and the last date for making the application under the scheme was 30/12/2019, and in fact the appellant submitted the application in form number 1 on before the last date specified for making an application under the scheme. After the form number 1 is processed, the designated committee was to scrutinize the same and issue the final form number 3 determining the settlement. The final determination form number 3 that the appellant was issued the form number 3 on 25 to 2020 and was required to pay the settlement dues on or before 25/3/2020. However, in view of the COVID-19 pandemic, the government extended the time up to 36/2020. Therefore, the appellant was required to deposit the settlement dues on or before 36/2020. However, even before the scheme 2019 came to be introduced, the appellant was subjected to proceedings under the IBC, which commenced when the NCLT admitted the application under Section 7 of the IBC. Thus, the moratorium under the IBC commenced on 11/9/2018. The COC approved the resolution plan on 4/6/2019 and the same came to be approved by the NCLT by order. Therefore, the moratorium under the IBC continued up to 24/7/2020. Under the provisions of the IBC, no payment could have been made during the period of moratorium. Therefore, the appellant was statutorily restrained from making any payment. There was statutory disability on the part of the appellant in making the payment during the moratorium. If the appellant had made any payment during the period of moratorium, the appellant would have committed breach of the provisions of the IBC. Therefore, it was impossible for the appellant to make any payment during the period of moratorium. Immediately on the moratorium coming to an end, the appellant approached the authority requesting them to accept the settlement amount under the scheme 2019 as per the form number 3. Such request has been rejected by the Commissioner. On the rejection has been confirmed by the High Court. Therefore, the short question which is posed for consideration before this court is whether, when it was impossible for the appellant to deposit the settlement amount in view of the bar and the restrictions under the IBC, the appellant can be punished for no fault of the appellant. In a given case, can the appellant be made to suffer for no fault of its own and be rendered remediless and denied the benefit, though it was impossible for the appellant to carry out certain acts, namely to deposit the settlement amount during the moratorium As per the settled position of law, no party shall be left remediless, and whatever the grievance the parties had raised before the court of law has to be examined on its own merits as observed and held by this court. No law would compel a person to do the impossible, stop